Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Globe Law and Business. It's actually written in conjunction with Legal Link. It's called International E-Discovery, a global handbook of law and technology, and it's been edited by the consulting editor Mark Surguy. A big thank you to Mark and of course to all involved at Globe Law for this publication, including the managing director Shana Neal. Now, I've given it a title for our review, an important statement on data privacy and management, data management that is, in the context of e-discovery. Big issue at the moment, lots of problems because of failures by certain people to provide the sort of relevant information you need. It's happened to me in the past as an advocate where I've actually found something which is crucial to the case which hasn't been disclosed initially. Big problem, and for advocates it's something you've got to be very well aware of right at the beginning. That's why I think the book is quite interesting. As I say, let's have a look at the book first of all. There's the front. It's done in the style of Globe, so it's like that. You can see the front bit there. There's the spine, and then there's the back. It's a bit difficult to read. I've taken some of the blurb from the back as part of my review because that explains what the book actually is. You've got some information about Globe at the back, some first-class information about some of their publications, and then you've got right at the back, you've got the authors. So as with quite a lot of publications today, the information about the authors is at the back, not at the front. You can see, and I'm working backwards here because there are a lot of people who've been involved. That's about the authors. There we go, right at the back. You can see what we've got. You've got some subheadings and some paragraph numbering, and you've got footnotes at the bottom. If I go to the front of the book, again, you've got the standard structure of Globe. There we go, there. And then you've got all the blurb there, and then you've got the table of contents, and you've also got the names of the people who contributed, so you can find out what they're talking about. And we're looking at different countries here, applying the technology, and looking things at stuff such as professional conduct, and how we transfer the data, and how the technology has evolved in the various countries. And then there's an introduction from Mark, who's from Waitman's. And it's worth reading. I'll just quote this. He says, data is everywhere. It has proliferated with cheap storage, absolutely, and yet it is valuable in litigation, arbitration and regulatory investigations, often in relation to suspected wrongdoing. And that's, of course, where we come in. Now, that, again, sets the scene nicely. It's a lovely book, this. I was very impressed with it. I'm very grateful to Globe for sending it to me. But this is what I say about the book. Globe Law and Business offer us, as practitioners, a well-researched publication, which, as far as we know, is a unique collection covering worldwide analysis on the state of knowledge and practice in the use of digital evidence in legal and regulatory contexts. So very fundamental to you as an advocate in practice. Do begin, as I indicate, by reading Mark Surguy's introduction, which sets the scene, I think, very nicely and opens the book well for those new to the subject matter. In other words, relatively new practitioners. The word discovery has been the subject of renewed legal interest recently in view of failures to provide documentation relevant to litigation within the England and Wales jurisdiction. I'm not going to mention particular areas, but criminal law obviously is the classic where we've had problems. Therefore, the new handbook is both timely and relevant at national and international global levels. Being compiled for Globe by hands-on technologists. I'm using the words they use. I think they're very good, actually. Hands-on technologists and legal practitioners. And it reviews the most recent developments in the principal legal centres of the commercial world in the use of leading-edge technology, enhancing the global requirements we have in 2019 and beyond. And of course, things have changed, and they are changing very quickly, even as I speak, with online courts coming in eventually after lots and lots of delays and blocks and everything else. And as legal professionals, we're aware of challenges we face in the courts across different parts of the world. Can I just remind you what Surguy said right at the beginning? He talks about the fact that there is a huge amount of data now available, a lot more than we ever had before. I'm going to mention that again in a minute. We also know that the issues are similar for all of us. However, as the contributors recognise, There is no single solution that solves the problem created by the vast volumes of corporate data that form the basis of investigations, litigation and arbitration. And these are vast quantities we're talking about here. And it really is a matter of selection. That's been the problem since the dawn of the internet. And of course it makes all of us aware of the huge amount of information which is now out there, especially when we are older practitioners sometimes, remembering the simplicity of the past. I certainly do. But however, things have changed. Now, global law and business remind us that computer science, with its statistical measurement, trial and error, and numerical approaches converging with developed and in some cases underdeveloped legal knowledge, practice and procedure in different corners of the world. And that's really why it brings together the various jurisdictions which are covered in the book. The task of bringing together then the skills and approach of two very different disciplines is the key to successfully maintain a system of justice that works for business at a cost that is not overwhelmingly disproportionate, because the problem has been cost. It's the bulk and complexity of the documentation and the costs involved. Fortunately, all the writers are experts in their own field and have reviewed issues including professional conduct, privacy laws, different levels of judicial awareness, the proper use of powerful search tools and techniques, and the likely shape of the future. And that really is the essence of the mission statement. And in one title for the first time, this is a most informative handbook, in my view, where, to use a legal expression, the veil is lifted to provide you with deep insights into what works and what does not, and where the money goes. And there are, of course, professional observations and tips on moving forward with best practice, country by country, which is, I think, most helpful for international lawyers. And the handbook has been rightly described as a must-have addition to the seasoned practitioner's library. It's certainly something I think you should be very well aware of. It's not a long book. It's well worth reading because it's quite easy to read cover to cover quite quickly. It's a vital read, I think, also for undergraduates and younger practitioners, giving the legal profession where it meets business with that essential background reading for both judges and arbitrators. And we found the book to be a clear and accessible practical text which succeeds in bringing together multiple professional disciplines into a single volume at a time when data management and privacy are so needed. And I think we've also got to be aware of safeguards in the future, because at the moment we are not actually capable of handling some of this, and that's, I think, why this book is quite helpful and quite timely. It was published on the 15th of August 2018, and I'm reviewing it just the beginning of the year, turn of the year. There's the book again. See the back of it, spine. Now, if I just open it in the middle, I'm here looking here at Canada. Now, Canada's got a very interesting jurisdiction in its own way. You have paragraph numbering. You've got the footnoting there. Of course, Canada has online courts. British Columbia does, in the province of British Columbia. Then France is the next one, and it runs through. And if I just go, I didn't mention it before, I will mention the countries: Australia, Canada, France, Germany, Ireland, Italy, Japan, Singapore, the UK and the US. So I think a really good book. Thank you to Sian, thank you very much to all the people involved, Mark and everybody else, all the contributors. I think it's an important book, probably more important than we're actually giving it credit for at the moment, because this is an area that's not going away, and it's going to get deeper and more complex and bulky as the decade unfolds. Thank you to all anyway. Bye-bye.